What if someone puts a house as payable on death, but then puts the same house in a trust for a different person? Which one rules? This is interesting. So the way it works with deeds is the most recent deed is the deed that prevails. So typically in a scenario, let's say somebody does a transfer on death deed. That's the terminology typically used for a deed rather than payable on death. Or like in Florida, we have ladybird deeds, which is a form of a transfer on death deed. So let's say somebody first does a transfer on death deed, leaving a certain person as the beneficiary of the home. You're supposed to record these deeds. That's what lets people know that this is what your intention is for the property, and also lets people know what the most recent activity is with regard to the home. So you have this transfer on death deed at list one beneficiary. Well, if a year later, a day later, 5 minutes later, the person then decides, oh, I actually want to put this home in my trust, and the trust would give the home to a different beneficiary. So they then sign a new deed putting the home in the trust, and they record that deed. Well, that new deed is going to trump the previous deed. That's how it works. You can, as the owner of the home, you can always change your mind. Even on a transfer on death deed, you can change your mind about the beneficiary and record a new transfer on death deed listing a different beneficiary or more than one beneficiary. And the deed most recently recorded, or the newest deed, is going to be the one that will trump the older deed. Now, the reason I said this is interesting is I have seen weird scenarios in my practice where people will prepare and sign what's called a pocket deed, one that they do not record. And I have run into scenarios where a person has deeded the same property to more than one person. So in this scenario, someone could actually have a deed prepared where they're leaving a home to a beneficiary under a transfer on death deed or a ladybird deed, and then also prepare a deed where the home goes into their trust and not record either of them. I don't know, maybe they're waiting to see what happens, or maybe they don't want to upset somebody, or maybe they want, both people to think that's where the house is going. I don't know. For whatever reason, I'm not even going to try to guess. It's a bad idea. This is a very, very bad idea to have deeds floating out there that aren't recorded, or preparing several deeds and then deciding later which one you want to record. This can end very badly and can end in litigation. There can be all kinds of arguments as to what was the later time, was one under duress, which one was created when, and what was the real intent. This is just stinks with litigation, honestly. So it's definitely better to, if you change your mind in a legal way that you're actually preparing a new deed, and then you record a new deed, which then takes the place of the older deed. I hope that's what this is in this scenario, in which case if it is, if somebody had a TOD deed, but then they later put it in the trust, well, the trust is going to prevail. It's that simple. If somebody, has deeds floating around that aren't recorded, I would tell them that that's, they should go see an attorney and have an attorney's help with regard to what they actually want to do with their home. All right, I hope this answers the question. If you have any other questions about transfer on death deeds, or about estate planning in general, probate, Medicaid, and you're in Florida, please don't hesitate to contact our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.